Good morning and welcome to day 6 of this hearing. Before we start, we just want to share, we took note of the news that in the Arequipa region there was this mining accident and a lot of workers died, a very tragic event. We want to express our deep sorrow and thought that we start with 1 minute of silence before we start the day. And then before we start, are there any issues the parties wish to address? We from our side would just remind us of our timing, so to say, for the week. Our expectation is that we will be done with all experts by Thursday evening. If there is a need for the parties or a preference that we start earlier on one day and later on the other, just share it with us. We are at your disposal, but just for timing purposes, this is our expectation that the Friday is really limited to the closing statements.
Madam President, that's also our understanding. I propose that we first confer with counsel for the other side whether we see a need for longer sessions on one or two of those days. Certainly from a preliminary calculation we have done in order for the parties to use the allotted time, it would probably be necessary to have on 1 or 2 days like an additional hour or two. But let us first confer and then maybe get back with a joint position, and if not, we will come to you.
Madam President, that is also our understanding, and we will confer with the other side to see if we need 1 hour or more in the next few days so that we can accomplish that.
Perfect. Then it seems that we can start. We will now continue with the cross-examination of Mr. Tovar. Welcome back to the hearing, and I hand over to Claimant's Counsel.
Good morning, Mr. Tovar.
Mr. Dietmar, good morning. Good morning, everybody.
Hope you enjoyed the nice weekend here in Washington. Let's travel in time to March 2005. So March 2005. In March 2005, you traveled to Toronto, right?
Mm-hmm. Yes, sir.
And the occasion for your trip was attending the PDAC conference, which is the Prospectors and Developers Association of Canada conference, correct?
Yes, sir.
And the PDAC conference is one of the most significant annual mining conferences, right?
Yes, sir.
And you traveled as part of a MINIM delegation, right?
Yes, sir.
And the main, you traveled to have a number of meetings with mining companies, but the main event was a panel discussion at the PDAC conference that MINIM organized for March the 9th, right?
Correcto.
That's right, yes.
And the purpose of the presentation at the PDAC conference was to promote Peru as a destination for mining investment, right?
Correct.
That is right, yes.
And there were representatives of Xstrata, Barrick, and Phelps Dodge who agreed to give a presentation at that event, right?
Yes.
Yes, that is right.
usually witnesses are too far away, so you're the first one who's too close. And the speaker for Phelps Dodge at that event was Mr. Red Conger, right?
Sí, es correcto. Sí.
Yes, that is right.
He was a vice president of Phelps Dodge Corporation and a board member of Sociedad Minera Cerro Verde, right?
Entiendo.
I understand he was chairman of the board of Cerro Verde.
So before you traveled to Toronto, Minem was preparing a legal aid memoir for the conversations that you would have at Toronto, right?
That's right.
And that legal aid memoir was prepared by Cesar Segarra, right?
Es correcto.
Yes, that is right.
So number 2 in the in Minem's General Office of Legal Affairs, right?
That is right, yes.
One was Mr. Isasi at the time, right?
Es,
That is right, yes.
And you testified at the last hearing that Mr. Segarra prepared that memo and then Mr. Isasi reviewed it. Is that still your recollection?
sí, siempre es así.
Yes, that was always the way it was done.
Mr. Segarra then sent you and Mr. Polo the memo to Toronto, right?
The Ed Memoir, yes.
And the topic of that aid memoir was the impact of mining royalty on tax stability agreements, right?
Así es.
That's right.
And that was a topic at the time because if you just put ourselves in the chronology, because in June 2004 the mining law had been passed, right?
La ley de
The mining royalties law that had been adopted on 11 June and officially enacted in late June.
Yes, and let me correct myself. I meant to say the royalty law has been passed in June 2004, not the mining law.
Es correcto.
That is right, yes.
Point in time, was still a case pending before the Constitutional Tribunal with regard to the royalty law, which was resolved in a decision in April 2005, right?
I recall that the decision was in late, unless my memory is wrong, was in late 2004, and in 2005 there was a specification because there were certain terms that were not written adequately in 2004. This is what I recall.
So let's take a look at the aid memoir. The aid memoir is Respondent Exhibit number 5, tab 11. You see it? Just to confirm, when you received that aid memoir, you reviewed it, I imagine.
Indeed, I reviewed it before it was sent to me because we still were maintaining communication with Lima while we were in Toronto.
Is it fair to say that Mr. Segarra, Mr. Isasi, and you, all three of you, worked on a memo or at least reviewed it?
Sí. Totalmente correcto.
That is correct, completely right. The concepts that were written there merely formalized what we already knew through oral discussion, but it was always best to have a document to back things up.
So let's take a look at that memoir. It says in the last two bullet points, there are mining concessionaires that have signed administrative and tax stability agreements with the state regarding specific mining projects, entered into the single unified text of the mining royalty law, the model agreement for which was approved via Supreme Decree number 494 EM. In this respect, for purposes of enforcing the guarantees agreed to by the Peruvian state for mining royalties, it is the mining company's responsibility to inform the entity tasked with managing and collecting the royalty about the mining projects and concessions that would be covered by such guarantees. Do you see that?
Yes, sir.
So let me ask you a couple of questions about that. This memo doesn't talk about investment projects that are set forth in the feasibility study, does it?
That's what specific mining projects refers to. This is a file that I found among my emails, and this is precisely one of the files that I sent the lawyers as an original attachment. Not in Word, but the original file. And what is in boldface there is from that time. Specific mining projects refers specifically to investment projects.
Tovar, mining project refers to mining units, doesn't it?
No. No.
No, I don't agree. I don't agree.
You describe the scope of stability agreement in your two witness statement, Mr. Tovar. You use the term investment project set forth in the feasibility study. You don't talk about mining projects, do you?
Good.
Mining projects is a term that's an equivalent to investment project. Project is something I'm planning to do. I'm planning to do something related to industry, fisheries, mining project. It is an investment project in mining.
The Spanish version, let's look at the last paragraph. It says, los proyectos y concesiones.
The mining projects and concessions that would be covered by them.
Cubiertas refers to the concessions, right?
To the projects. Actually, the scope of stability agreements is not for the concession. The concession is not what is stabilized, and that is even been written by the Constitutional Court. In one way or another, it explains that what is stabilized is not the concession, which is governed by its own rules. What is stabilized is the project that gives rise to the contract and which is set out in the feasibility study. It is what is said in the mining law and the regulation, and when the company in 1998 submitted its feasibility study, it described, it delimited in time, in tons, in type of ore to be processed, in type of waste. Indeed, there is a paragraph in that feasibility study in 1998 that describes what waste would never be generated. And this is a project that will not produce tailings. That's what the feasibility study says.
We're not at the 1998 feasibility study now. We are at this memoir. Mr. Tovar, cubiertas is in feminine and refers to concesiones and not to projects, does it?
I don't agree, Mr. Dietmar. When one drafts in the Spanish language, one can use a neuter article or make reference to the last word when there's two words. It's simply a way of drafting in the Spanish language.
The concessions are not covered by the guarantees? Is that what, in your reading, that sentence says?
What is stabilized by the law, and one has to review the drafting of the mining law and several articles of Supreme Decree 04, the regulation, which says not in just one way, but in more than one way, the subject matter of or purpose of the application for the stability agreement. And that is a criteria.
Talking about the mining regulations, which refer to the mining units and concessions. We are talking about this paragraph. Are you telling me that under your interpretation of the word estarían cubiertas. The concessions are not included in the cubiertas. Is that your reading?
Mr. Dietmar, the mention of concessions in the agreement is to give a geographic location to the project. That is the purpose of mentioning the concessions.
Mr. Toba, it doesn't say the projects in the concessions. It says the projects, meaning the mining projects from the previous paragraph, and concessions, mining concessions, that are covered by the guarantees. Would you agree? It doesn't say the projects in the concessions?
But that is what the document refers to, Mr. Dietmar. That's what it refers to.
Mr. Toa, you would agree the project doesn't mention anywhere Cerro Verde? The 8th memoir doesn't mention anywhere Cerro Verde?
No, it's not specific. The application of the law is not for a particular company or project. It's of general application.
So the memo does not specifically address whether the new concentrator of Cerro Verde would be covered or not by the royalties.
Mr. Dietmar, these aide-memoirs were for cross-cutting application. They were for general application to all projects, not for a particular case.
Mr. Tuba, you had on the 8th of March lunch with Mr. Conger and with Mr. Luis Carlos Rodrigo, correct?
Sí, señor.
Yes.
And in your first witness statement, at paragraph 55, you said that you and a group of unidentified minimum officials had traveled to Toronto and we had lunch. Okay? In your second witness statement, paragraph 81, you said that I had lunch and I made certain explanations at the lunch. At the SMM hearing, you said that Mr. Polo and you were at the lunch. So my question is, do you have for us today a fourth version of who attended the lunch, or can you pick for us one of the three previous ones?
Mr. Dietmar, the version of, there's only one version of the situations where I was present. Perhaps what we're seeing is that the first statement that I gave in March or April of 2022 did not have so much so as to be able to refresh my memory. And for the second witness statement in November, I looked thoroughly into my file so as to have a greater clarity as to, well, even as to the name of the restaurant where we had met, because it's humanly impossible to remember the name of a restaurant where one had lunch after so many years, and I found that among my emails. So in reviewing these emails, I found the original presentation by Phelps Dodge made by Harry Conger, and on reviewing and remembering those documents, then one begins to remember particular additional details.
So you're telling us today that when you wrote the first witness statement, you couldn't recall who else on behalf of Minem attended the lunch?
I vaguely remembered that it was Cesar Polo, but when I looked at the documents more extensively, I clearly remember that it was him. And that's when I found the agenda, the schedule of meetings, and that's where I remembered that we had a prior meeting at barracks offices, which were a block away, and we got to the lunch with Phelps and Mr. Rodrigo and Mr. Harry Conger late. So one begins to remember those things once you review documents more.
So when you wrote the second witness statement and had seen the agenda, you recalled that you had the lunch with Mr. Polo.
Yes.
Yet in your second witness statement, you say, I had the lunch, and I said, and you do not mention Mr. Polo in your second witness statement, Mr. Tovar.
Madam President, I object because he's misquoting the second witness
Okay.
statement. In paragraph 81 of his second witness statement, he says, during this visit, I am making my own translation because I'm looking at the Spanish. We had lunch. Tuvimos un almuerzo.
Well, let's look at the second witness statement, paragraph 81. It says, during that visit, I had lunch in the Farniente restaurant with Phelps Dodge president.
Hay un error de traducción en la versión en español.
It's a translation mistake in the Spanish language version, which is what I actually wrote. It says, during this visit,
Tuvimos un almuerzo.
we had lunch. So there's a mistake in the translation.
You don't mention Mr. Polo in the Spanish version either, do you? Translation mistake if you
Claro,
did
pero
in
eso
the
no genera-
Spanish, but not in the English. So you did not mention Mr. Polo in either the Spanish version or the English version of the witness statement, do you?
Eh,
Yes, you're right, but that doesn't give rise to any contradiction. I wasn't at the meeting alone. Indeed, I remember where I was seated at the table. It was a table where there were just 4 people there of all those who were invited, Mr. Harry Conger, Mr. Rodrigo, and I was seated here, and Cesar Polo was seated here.
Mr. Tovar, you testified on Friday that you reviewed Mr. Polo's witness statements before you signed your witness statements. Did it strike you as odd that Mr. Polo did not mention the lunch in his witness statement, although he talked about the application of stability guarantees to Cerro Verde?
To be more specific, Mr. Dietmar, while I have had the PDF when doing the final review of my first statement, I did not study Mr. Polo's statement in detail, just some paragraphs that the lawyers found were in agreement. They noted that, well, these coincide, so the 2 agreements are the same. But it's only normal, it's only natural for someone to have a clear memory than someone else regarding some event that took place many years ago.
sobre todo en mi caso,
Especially in my case, because I was the one who was in charge of the schedule. I was the one who organized the schedules. I would put the schedules and the distance and the times together to make sure we'd go from meeting to meeting and be on time.
Second witness statement, it didn't strike you as odd that Mr. Polo didn't mention a lunch in Toronto.
le juro,
I can swear to you that I've never seen that detail because I did not study Cesar Polo's statement. If you ask me how many pages does it have, I don't know. I haven't studied it. I took a look, but I did not review in detail what Mr. Cesar Polo said.
So you mentioned at the lunch that at the lunch, well, let's start with the second witness statement since we have it up. You said, I explained to Mr. Conger and the attorney that because the leaching project was covered by the stability agreement, it would be exempt from royalty payments, but the concentrator project would not be. And at the SMM hearing, you said that, well, actually it was Mr. Polo who made that statement. And you may have helped a bit with the translation. What's your recollection today about who made that statement?
I remember having said it. It's possible that as a reply to or to support what Cesar Polo had said at that time. But we'll understand that in a lunch, unlike a formal working meeting, one is a bit distracted working more than focusing exclusively on talking or discussing things with pen and paper on the table. So it was a very friendly, cordial, and transparent meeting or lunch. But I think that I must recognize we got to the lunch late, I think more than half an hour late, so we were a bit rushed. I do remember that. But the lunch meeting we did not ask for. We asked, and I say this because I organized those meetings at the PDAC meeting, we asked for the presentation in the ballroom at the Intercontinental. And in exchange, the company says, well, after that presentation, now that we're there, let's get together on a more social basis. That happened with Barrick. There was coordination with, and with Phelps, we got there late.
Who gave the message? Was it Mr. Bolo or was it you?
I would say it was both of us. But I do remember having said it.
So in today's version, both Mr. Bolo and you gave the message at the same time, or he first and afterwards you, or?
Muy posible.
It's quite possible that Cesar Polo may have made the first comments, and then I would have repeated it in English.
And Mr. Toba, did you have at that point in time a legal opinion from the legal office or from the DGM that determined that the stability benefits would not apply to the concentrator? We saw that the 8 memoir didn't mention Cerro Verde. So did you have any other document at that time that stated that the stability benefits, the stability guarantees did not apply to Cerro Verde's concentrator? What did you base that statement on?
At that time, in March of 2005, the reading and knowledge of the scope of application was quite clear. And I'll be honest with you, I did not have reports for each article or as to how each article of the law would be interpreted. The reading of the law and the regulation, a direct reading of it, led to an understanding of the scope of coverage. And my oldest memory in terms of understanding the scope of application of the Stability Agreement is from March or April of 2004. March or April of 2004. And I came into the MINEM in January. And by March, one already heard, it was already known that there was this debate about the royalties law internally. And we had to know how it would be applied once promulgated.
Toba, you were basing your alleged statements on your understanding of what the application of the stability guarantees would be on Cerro Verde's concentrator and not on a legal memorandum. Is that correct?
Let's recall that every Monday at 10 a.m. we had a general meeting with engineers, lawyers, sociologists, and so on, and there all the opinions were shared. If you're suggesting that the opinion on coverage is my own personal one, I can confirm for you that that's not the case. It was institutional.
Mr. Dover, you had a special legal aid memoir prepared for your meetings to address the question of whether stability guarantees applied to, or what the scope of stability guarantees was with regard to the application of the royalty law. That legal opinion did not address Cerro Verde, and yet you felt authorized without a legal opinion to make that alleged statement?
You're mistaken, Mr. Dietmar, with all due respect. The fact that this aide-memoire exists in March doesn't mean that previously there hadn't been discussions and knowledge of an official institutional position on this matter.
Mr. Dover, you testified in your second witness statement that minimum official can not provide any oral opinions, that they can only provide opinions in writing, and that it would be outside of their duties to provide any oral opinions. Did that rule not apply to you and to Mr. Polo, only to Ms. Chapuis?
Mr. Dietmar, your question is extremely important, relevant in this general case, not just in terms of the questions you're putting to me, because what I have done is to explain to all regulated parties how the law is administered. What is totally prohibited is to suggest to the regulated party how they should do a filing that one is going to evaluate. This is very important because in the witness statements that I've read by the claimant, it is written that someone in the ministry made that suggestion as to how to establish a legal strategy for the regulated party, and I believe that that is something that should not happen. It's one of the first things that the lawyers explained to me and taught me. Don't give ahead of time an opinion on some filing that is about to be made. You're referring to Ms. Chapuis, is that correct? Yes, sir. When did you find that Ms. Chapuis had said that one must follow this line? What did you do? Mr. Santiago, during the time that Ms. Chapuis and I worked together at the Ministry of Energy and Mines, I never heard or received any sort of instruction like that from her, not orally or in writing. So how did you find that out, and when? We have heard statements that she knew that there was a different position in the ministry. When I read these witness statements written, and that was in January, February of 2022, when I began to be a witness in this case, and once I had access to these documents in PDFs, that is where I saw that there was a version that was not shared with us. In all of the documents, in all of the memos, in all of the emails, even, this position of Ms. Chapuis is not reflected. You did not know that she had a different position? No, sir. No. Not orally or in any meetings. Moreover, there is a trace of a presentation by Verde from August of 2004, where in the meeting I mentioned that among the existing procedures of the ministry is the possibility of them signing a new stability agreement. That was and could have been the moment when any of those at the table could have told me, why are we going to sign a new stability agreement if this is already stabilized?
And you worked with Ms. Chapuis, right? She was your direct boss. Yes, she hired me. Some witnesses said that the disagreements were well known in connection with Ms. Chapuis, but you said that the ministry did not know that. You refute those witnesses. Specifically, for example, this was indicated. By Mr. Isasi. He said that the disagreements in connection with Ms. Chapuis were well known, but you say that they weren't. I can give you an example. No, please answer my question. It is not true that there were no differences, meaning that Ms. Chapuis opined like you all did. No, in certain cases there were disagreements, and I had to take the case to Ms. Chapuis and support the case. In connection with this issue specifically, that were not known, the disagreements that Ms. Chapuis had? No. Otherwise, there would have been a record. And in connection with the royalties law, specifically once the law was passed at the end of June, and we had the Monday coordination meetings with the Vice Minister, she sent an email in connection with the royalties. She said, well, I did not participate in the meeting in connection with the royalties. Thank you. Let me ask you, Clemens asked in writing that the ministry respond in writing that the concentrator was covered by the stabilization agreement. No answer was provided, and this lack of reply by the ministry, was that done on purpose? Was that dealt with on the Monday meeting, that there was no issue here? That silence, is it interpreted as a negative? I'm sorry, I can't see your last name. You can call me Mr. Arbitrator. Okay, Mr. Arbitrator. It is correct that Saraberde made presentations. I do clearly recall one in August. I don't remember the one that was mentioned in June or July. In these presentations, they said that they were going to apply for the inclusion of this project within the stabilization regime. But that application, I never got to know. It never came to me. Thank you very much.
And I ask about these presentations that Cerro Verde made in July and August 2004. As the other arbitrator has asked, they had specifically asked in the presentation for an addendum of the stability agreement. Do you remember that this presentation was held and that they showed the slide and asked for this addendum of the stability agreement?
Council showed me two presentations. One from June, July, or the other one from August. I remember the one from August. Apologies, Madam President. I remember where I was sitting at the table in some cases, and I do remember the August presentation. The first presentation, June, July presentation, I don't recall that one. I do not recall that because when I reviewed it, there were so many issues where I would have interrupted the meeting and issued my opinion that I would remember. I remember, okay, for me to have either waited or not said anything. Memories are reconstructed after many years, not only based on a piece of paper, but based on the events. If we look at the August presentation, we can see clearly that the company has asked for the signature of an addendum and the incorporation of the concentrator. So the spirit of the August presentation matches the email that Chapuis sent to the directors in June, asking whether the incorporation of the primary sulfides project is legal, incorporating that into the contract or the agreement. So the reading that I had in June of that email by Ms. Chapuis and the one in August, the presentation in August, makes me think that the primary sulfides project was clearly not included in the 1998 stabilization agreement. Now, if we go back in time and we look at the documents, the perception is clear. Ms. Chapuis and the company were asking for the incorporation of primary sulfides in the stability agreement. There was an email by Chapuis on 11 June, and there was also a presentation by the company in August in that connection.
Do you remember that this addendum to include the concentrator was then discussed in this meeting and that a response was given by Ms. Chapuis or yourself or anyone else of the ministry?
I do not have any personal knowledge of the fact that the company has submitted that addendum application. If that had come to my office, the office would have acted because my office was the one in charge of preparing reports in that connection. More importantly, is that the work route for an application of this kind does not end at the DGM. The DGM does not sign contracts, 10-year contracts or 15-year contracts. No, that is done by the minister and the vice minister. If that application had come to the office, I would have seen it as it should be done, and it would have ended up at legal because of the signature by the minister or the vice minister and by the general secretary's office if it's signed by the minister.
According to my understanding of the organization, and now there was a legal advisor to Ms. Chapuis, and I understood you were advising on promotion of investment, which was more technical. So why would this application, if it existed, had come to your attention?
Because the regulations for organization functions so states.
Thank you.
Just a couple of follow-up questions. Mr. Toba, the suggestion in the August presentation of an addendum assumed that the concentrator would have a separate beneficiation concession, didn't it?
At that time, the company had not submitted its request for the modification of benefits. So, no definition was given at that date during the Cerro Verde presentation in August.
Mr. Toba, Cerro Verde never requested that the concentrator be included, that the concentrator gets a separate beneficiation concession, did it?
Es correcto.
That's correct.
Verde requested that the concentrator be included in the existing beneficiation concession, correct?
That's correct.
And you approved that it be included in the existing beneficiation concession, correct?
It's legal, it's correct.
Proposal about the August suggestion in the PowerPoint presentation about an addendum assumed that the concentrator would get its own beneficiation concession, a separate beneficiation concession, and that then the stability agreement be extended to include it, didn't it?
Well,
Can we look at that slide in particular?
You see, can you see here? Separate beneficiation.
está aquí en la...
Where is it?
I think we have it, but you can see it on the screen. You see it's a separate beneficiation concession.
Porque lo que pasa es que esta tiene varias diapositivas.
There are a number of slides here, and you have to look at things in context. You have to look at the other slides, and not only this one.
Tab 34 in your binder. You see this one, the proposal, would you agree with me that you see here assumed that the concentrator would get its separate beneficiation concession? Isn't that the case? If you look at the slide. Mr. I don't want to lose all the time for you going through all the presentation. You're at Council for Peru. Can I ask you some follow-up questions on that? I want you to look at that proposal here in the slide.
Excuse me for the delay.
De beneficio planta concentradora de sulfuros primarios. That would have been a separate beneficiation concession from the existing beneficiation concession, correct?
I had a doubt when I heard your question. That's why I looked at this slide. But at slide 40, the company asks the question, is it necessary for the plant to have a beneficiation concession under the addendum? They did not have a position taken. Their position was not fixed. They were looking at possibilities.
The presentation way of saying, and then it provides the answer right beneath. I focus here on page 11. That is the proposal that you mentioned about the expansion, and this proposal assumed that the concentrator would have a separate beneficiation concession. Yes or no?
On this slide, yes, but if you look at slide 40, in the same presentation, at the same meeting, they posed the question. They are exploring alternatives. They are presenting an inquiry. If you look at the presentation in full, the company has gone there to explore the alternatives that would be more convenient to it.
Mr. Toba, can a beneficiation plant function without a beneficiation concession?
Formally, no.
So you either include it in the existing beneficiation concession or you ask for a separate beneficiation concession, correct?
Well, an extension, an amendment.
And this proposal assumed a separate beneficiation concession. You still haven't answered my question. Take a look at the slide. It says concesión de beneficio planta concentradora de sulfuros primarios.
I answered that this slide has been drafted as it has been drafted. I have answered, but the spirit of the presentation is to ask questions and explore alternatives.
And you then approved the inclusion of the concentrator in the already existing beneficiation concession, Mr. Toba.
Because that's legal. We spoke about that on Friday. It is one of the two legal alternatives that we had. But I also said that these are different procedures that are independent, and this was corroborated by one of Clateman's witnesses. I remember a phrase that I read. These are not my words, of course. They're the witnesses' words. Of course, these are independent procedures, and we can look at it if you want.
Toba, you also... Sorry.
You just referred to another slide on page 40 to support your understanding. Can we just have a quick look to the slide number 40? So, if you explain your understanding of this slide.
This presentation has been prepared by the company, not by the ministry. It says, is it necessary for a primary sulfide plant to have a beneficial concession when including the addendum? And this matches what we saw at slide 11. The answer is no. This type of agreement, and this is what the company says, is signed before or during the accomplishment of the investment, and the beneficial concessions are granted when completing the construction.
Quiero insistir.
I insist. Stability agreements do not stabilize concessions, but investment projects, mining investment projects.
Mr. Toba, you mentioned the consistent position of the minimum at the time. Let me just ask you, you testified on Friday that you copied the entire hard drive of the that you had from Minim. You have not presented a single email that would show what position the DGM or Minim had with regard to Sierra Verde Stability Agreement, did you?
Es correcto.
That's correct. That's a recurring question. I answered the question when the arbitrator posed the question to me, because as far as I'm concerned, as I am personally concerned, there was never a contrary opinion to what we understood institutionally as the coverage of the stabilization agreement. My earliest recollection in connection with the position of Minim was March or April 2004.
Found any email describing what was being discussed at the lunch in Toronto with Phelps Dodge?
You're right. There was no aide-memoire drawn up for that meeting or for any of the other meetings held in Toronto.
There's not a single email that you could find that would anywhere state that Sierra Verde's concentrator would not be covered by stability guarantees.
I haven't found any, but also there weren't any, I insist. This was an issue that was well known already. This was cross-cutting. It was the Minim had a cross-cutting position already on it.
Telling us here today that you explained in Toronto to Phelps Dodge that a concentrator would not be covered, that Sierra Verde would have to pay hundreds of millions of dollars in royalties.
No,
and there's
César.
not a single document that you could find in your electronic records that would support that.
Sir, to be more precise, I never said hundreds of millions of dollars. I just focused on the concept and explained it. And the investment project that gives rise to the contract is stabilized. If that project is not included in the request for the contract, no stabilization exists.
You also said in your first witness statement that the discussion was triggered by Mr. Conger showing a letter he received from Sunat asking mining companies to declare which concessions they had in order to pay royalties. Is that right?
To be precise, he did not show me the letter. He mentioned that letter existed. He mentioned that to me. To be doubly precise, this was not done during the Tuesday luncheon, but at the end of the presentation in the boardroom of the Intercontinental Hotel, where I was standing, close to the door. The presentations were shown in the atrium, and the PowerPoint was shown there. And I was standing right there, and Mr. Conger stood up, and he asked a question while standing up. And that's where I found out, and he mentioned to me the existence of this Sunat letter.
Mr. Duba, in your first witness statement, you didn't mention a second meeting, did you?
I clarified that during my February testimony. The recollections I had during the signature of my first witness statement in April were supplemented with additional information that I found, because I looked for information again, and for my second witness statement in November, I found more information. I found schedules, agendas, emails, an email where Sierra Verde asked for a meeting. The original presentations, I did not recall that I had those.
So we found all these emails. We're going to come to the second meeting in a moment. But with regard to the first lunch, you found all these emails about where the meeting is going to take place, what restaurant is going to take place, agenda, etc., but not a single email about what you would tell, what you say that you told Sarah Bird at that meeting. Is that correct?
That's correct. I report to my boss. If my boss was with me at the meeting, and I'm trying to understand your question and look at it from different angles, what sense would it make to send my boss an email on the meeting because my boss was with me at the meeting?
Your boss is the Director General of Mining, right?
Yes, my boss was the person that occupied the position at the DGM. Ms. Chapuis occupied the position until December 2004. In Toronto, Ms. Chapuis was no longer there. This was December 2005. So the director was Mr. Cesar Rodriguez Villanueva.
Mr. Tuba, what was Mr. Conger's reaction after he was supposedly told that the concentrator would not be covered by royalties?
Total.
He was very calm, fully calm. He was not surprised at all. I was with him and we were a meter apart. No, there was no confusion.
So your testimony is that you were telling him that the concentrator would not be covered by stability guarantees.
Así le
And
dije.
That's what I told him.
he would have to, that as a result, Cerro Verde would have to pay hundreds of millions of dollars in royalties. And he was completely tranquilo.
Nunca.
I never used that phrase that it had to pay hundreds of millions of dollars. $1, $100. The application is conceptual. Mr. Conger, let's recall, is an engineer. As engineers, we look at the numbers before we take a position as to the viability of projects.
Mr. Tovar, at the SMM hearing, Mr. Conger was, in your recollection at least, surprised and pushed you to have a clear answer.
Lenar.
Let me tell you how that happened. I was sitting right there on that side of the room, looking at the presentation, and when I turned around, Mr. Conger was
The lunch.
My apologies.
Is that he was completely quiet? Okay, so let's look at the next day. Do you recall Mr. Conger having given a presentation at the Royalty Forum?
Sí.
And you
Yes, I do.
attended at that presentation, were you? Sorry, and you were present at the presentation, right?
Sí.
I was.
So let's take a look at the presentation. We have it in, it is tab 14, CE 945. You recognize that as the presentation?
Sí, señor.
Let's go to
I do.
9. So on slide 9 of that presentation, Mr. Conger explains that Cerro Verde had a pre-feasibility study. You see that?
2002, yes. That shows us that it was impossible for it to have been included in the 1998 contract.
Okay, I asked you whether you see it, and my question was, do you see that said here that Cerro Verde initiated preliminary discussions with the government on a number of issues, such as reinvestment of profit benefit, but also on stability contract assurance. Do you see that?
Discussions that started in 2002 and in their records of them in 2003. At those dates, there was no discussion of the royalties law. When it talks about stability contract assurance, no reference could have been made to the royalties law because it simply did not exist at that time.
Well, here he's talking about the preliminary discussions that started in the year 2002, right?
It is in the records. There are reports signed by the DGM in October and September 2003.
12. Here Mr. Conger explains at the PIDA conference, at the Minim event, that to make an investment decision, Cerro Verde and Phelps Dodge were having, you see the third bullet point, extensive interaction with the government. And they set requirements to proceed, certainty of stability contract. Do you see that?
Yes.
I see that.
And then let me get you to the last slide that I wanted to discuss, which is slide 16, in which Mr. Conger made his conclusions. And in the conclusions, on March 9, 2005, Mr. Conger tells the PIDA conference at the Minim event, the stability contract provides certainty to make $850 million investment decision. Do you see that?
Of course, in both cases, the reading of this and that anyone could have of this at that point in time is that how is it that one can use the stability agreement to reinvest profits from a component that was previously stabilized under the contract?
I was thinking about Mr. Polo being present too, but Mr. Tovar, the reinvestment of profit incentive is a separate bullet point. Here in the bullet point above the reinvestment of profit incentive, he refers specifically to the stability contract that provides certainty, and I say certainty, to make $850 million investment decision. That was what Mr. Conger said or presented to the audience at the PIDA conference at an event promoting Peru. Isn't that the case?
Mr. Dietmar, nowhere Harry Conger, Phelps Dodge, or anyone in this presentation said that Cerro Verde or Phelps had the certainty that they were not going to pay royalties. So much so that if we look at slide 2 of this presentation, Harry Conger invites the participants to look at the 10K report that was just published. They had been published 2 days before and sent to the SEC. And there, Phelps Dodge says in writing 2 days before that Phelps Dodge did not know how the royalties law was going to be applied to this project.
Reading the boilerplate from the first page. On page 16, in concluding his presentation, Mr. Conger showed the audience stability contract provides certainty to make $850 million investment decision. And Mr. Tovar, are you testifying here today that you or Mr. Polo told Mr. Conger the day before, hey, the concentrator is not covered by the stability agreement? And Mr. Conger the next day goes at an event promoting Peru in front of an audience of mining investors and tells them stability contract provides certainty to make $850 million investment decision. Is that your testimony?
Sí, pero no hay contradicción.
Yes, but there is no contradiction, and I can explain. A day before and after this presentation, I told Mr. Conger the sulfide project is not covered by the stability agreement, but it doesn't say here that it is covered. It says that the stability agreement provides certainty to make an 850 million investment. Why does it say so? Because it was possible to reinvest profit so as to save 30% of this value of 850 million that I signed. I signed that profit reinvestment, and what it implies is that the company saves 30% of the investment in the form of income taxes. So clearly, it was feasible. They used it, but there, it doesn't say there in the presentation, it doesn't say that it was for royalties. And the royalty law was existing at that point.
Tovar, the reinvestment of profit incentive is a separate bullet point. He says in the first bullet point specifically, stability contract provides certainty to make $850 million investment decision. You mentioned the reinvestment of profit incentive that you signed. Let's take a look at it.
Señor Dietmar, perdóneme.
Mr. Dietmar, I apologize for the interruption, but also slide number 2 invites to read 10K to present it to SEC. So I am asking you to read that 10K document and presented by Mr. Dodge, where they say that they do not know how the royalty law would be applied to their investment, and the whole presentation is given within that context.
This is the reinvestment of benefit profit decision that you signed. We have it as exhibit CE 479, which you can find in tab 10. That is from November, right? That is from November 2004. Can I have the document, the hard copy?
Sí, señor, sí.
You see it?
Yes, sir. Yes, sir.
Sociedad Minera Cerro Verde enjoys tax stability according to the agreement signed on February 13th, and it includes a special system to reinvest profits. You see that?
Sí, señor.
Yes, sir.
Among other benefits, it says. You did not, in that resolution, say anywhere that it's the leaching project of Cerro Verde that enjoyed benefits, but not the concentrator, did you? You said Sociedad Minera Cerro Verde.
Muchas gracias por la pregunta, porque
I thank you for the question, because that is clarified in the ministerial resolution that signed by Mr. Cesar Polo, Ms. Chapuy, and the minister, if I am not wrong.
Sorry. Mr. Toba, I'm now talking about what you were writing. We heard testimony about the other resolution already. I'm talking about this specific resolution. You did not say what you testified here today that it was the well-known view that the stability benefits only apply to the leaching project. Here you examine in quite some detail the approval of the program for reinvestment. You did not state, did you, that the stability benefits only applied to the leaching plant here, right? Mr. You did not state here that the reinvestment, that the stability agreement only applied to the leaching project. You wrote it applied to Sociedad Minera Cerro Verde. Did you?
This is not the only report that I sent for signature. I also sent a draft of a ministerial resolution.
Sorry, I just had to interrupt you about that. Mr. Deva, I'm not talking about the ministerial resolution. We heard testimony about that. You signed this report, and I presume you're very careful. You were a very careful ministry official, weren't you?
Thank you.
Yes or no?
I thank you for that compliment because I just found it here at the beginning of the document.
Al comienzo del documento.
At the beginning of the document, it says, subject matter, request the approval of reinvestment for non-distributed profits of the years 2004, 2005, 6, and 7, the years in which the primary sulfides was under construction. They were not producing, they were not invoicing or generating any profits.
You still have not answered my question. When you described the scope of the stability agreement here, you did not say that it applied to a particular project. You said it applied to Sociedad Minera Cerro Verde, correct?
No.
No, Sociedad Minera Cerro Verde is the holder of the concession, the holder of the contract, but the contracts define the holder, the project, the product that is stabilized, the tonnage of reserves, the years, the amount invested. The contract provides for many things. It does not stabilize the concession, rather the investment project.
Do you have questions in Greek direct?
Yes, could I take 3 minutes, please? May I? Thank you. Buenos días, señor Tobar.
Good morning, Mr. Tobar. Good morning, Mr. Tobar. Very good morning to you. On Friday, you were asked about the number of hours used to prepare your statement and to prepare ahead of the hearing. Are you being paid for this statement? No, not at all. I was paid the ticket, hotel, that's it. Now, if we can show on the screen RE233. On Friday, you were asked about the dialogue table. June 6th.
We did not discuss the roundtable discussions. We discussed an presentation that he said that he claimed was being made by Mr. Isasi.
Yes,
We didn't get to the roundtable discussion. So I think that question is like out of scope for a redirect.
No, I will clarify. Le preguntaron sobre una presentación.
You were asked about a presentation done on June 23rd, 2006, correct? Yes. And you mentioned that you had seen the impression of how you used to distribute this presentation. We are going to look at page 4 of the document. 3.2. We're going to zoom in for the witness and also in English. Would you read the first sentence of that paragraph? Once the round table was brought to order, I am sorry, but who's writing this? Clark, this is not mine, correct? No, it's not. Once the round table was brought to order, we were then provided with an extensive defense referred to in the PowerPoint-bound copy attached to the minutes regarding the reinvestment of profits and mining royalties of Cerro Verde, on the first page of which we can see in the second chart the timeline explaining that from the time of signing the legal protection agreement on 2/13/98 until the issuance of Ministerial Resolution number 510/2004 of December 9th, appendix to the action 1T, 3 legal rules were issued that did not impact the 1998 Legal Protection Agreement of 98, attached to or appendix to the action 1P without considering that the same legal protection agreement expressly prohibited. And we now look at page appendix A6 after the end of the document. Page 20 of the PDF. What do you think of when you see this? Well, what we see to the left is the type of presentation that Felipe Isasi did. not myself. My style for presentations was different. I even recall that this presentation in black and white had a dark, probably dark blue background. And this chronology was the way in which Felipe Isasi broke down the case to explain it in an easy to understand manner. And even though there have been claims by mayors, Congress members, when receiving the presentation, they were able to understand it, and therefore not a single word was changed from the ministerial resolution approving the 2004 profit reinvestment. There have been claims and questions, but the ministry never changed a single letter because this allowed them to easily understand this. Thank you. Now, you were asked about the exchanges you had with Henry Conger at the PETA Congress in March 2005. Do you recall those questions? Yes. Could we please look at the first paragraph or your first witness statement at paragraph 55? And halfway down the paragraph, this is describing the lunch meeting you had, and halfway down the paragraph you describe Mr. Conger's reaction. And Mr. Rodrigo, would you please explain what your recollection is? Certainly. I remember several things. First, this was 1 block away from our meeting, and we just rushed to that meeting. We were almost more than half an hour late. At the outset, it was the lunch whereby Cerro Verde was inviting the minister and some others. That the meeting was with Barrick, that we were away. But at the end of the day, the invited ministers, Director General, members of Centromin, Jorge Merino, Luis Moreno, etc. But finally, only Cesar Polo and myself attended, and they were a little bit hurried up at the table because we arrived late, but silence is uncomfortable, and someone usually takes the floor. Cesar Polo is very talkative, and that's when we precisely talked about something that was up to date, what's going on with royalties at Cerro Verde. It was a current issue. And then you were asked about Henry Conger's reaction as part of the second interaction on the second day. Could you please explain what Henry Conger's reaction was? When all of the presentations at the ballroom were over at the Intercontinental Hotel, this was on the next day, Henry Conger approached me. During lunch, nothing was said about the Senate letter. And he approached me. Henry Conger is a very tall person. He was very surprised. He was tall in relation to me, and even though he didn't show me the letter, he told me that there was a letter. We had heard about it with Altamina, who had told us about that letter. But since I knew that those letters from SUNAT had already been sent and they were quite generic in nature, the spirit of that letter that SUNAT sent to the companies was, hey, you know what? The ministry is telling me that you produce mineral. Please let us know if you need to declare and pay. So, at that point in time, March 2005, Cerro Verde only produced lithium cathodes that was for a project that was stabilized. So in March 2005, April 2005, May, Cerro Verde was not going to pay royalties because their operations had been stabilized up to date. But the project that they had just started building in November, December, January, February, March, after 5 months of construction, upon construction, they were going to pay royalties. I mentioned that to Mr. Henry Conger. I recall I said, clearly leaching does not pay, but primary sulfide, since it is not part of the contract, will have to pay royalties in the future. And he said, well, but this is not what the letter says. I said, do not worry. This is something that is being implemented right now. And there are some documents sent to Senat that will be more specific. And he said, okay, thank you very much. And he left. Thank you.
Madam President, can I make a very brief redirect?
Yes, please.
Mr. Tovar, I'm showing you a report from El Heraldo about the June 23rd, 2006 meeting that at which you claimed that Mr.
sorry.
Isasi made a presentation.
I am going to actually repeat the objection that claimant made. I wasn't asking specifically about the June meetings. I was asking about the presentation, and that was the scope of my redirect.
And I am establishing, I'm talking about the presentation here, so no worries, we are not talking about anything else. At the SMM meeting, we established that El Heraldo is the official newspaper of Congress, right?
Sí, señor.
Yes, sir.
¿Puede decirme en
We
qué
also
página está?
established that this article provides a description of the meeting that took place at the Royalty Forum, right?
Es correcto.
That is correct. Could you please tell me?
The one who's asking the questions. You would agree with me that this detailed summary of the meeting does not mention any presentation by Mr. Isasi or anyone else from the ministry, does it?
I think, Mr. Dietmar, that we should read these documents together. There are some minutes that I would like to see on the screen too, because I think that one complements the other one. The official minutes state that in principle it was at the Volumesi meeting. It was not at the Volumesi meeting room, rather at the Grau meeting, as it says here. The other minutes also show that there were some interventions or participations. I do not think that they contradict each other, but they supplement each other. And by the way, this was not the first time that we took to Congress a presentation on the scope of the royalties and the stability agreement, and that was June 8th, 2005, when we first did it. And I recall, because by chance, I don't know how the audio was obtained, and the minutes of that meeting of June 2005, that whereby they repeat exactly the same concepts. The stability agreement only stabilizes investment projects in connection with leaching.
Anticipated, isn't it?
I wouldn't be able to assert that.
Second follow-up question was, you did not, going back to the 2005 Toronto meeting, you did not mention a second meeting with Mr. Conger in the aisle after the presentation in your first witness statement, did you?
Está en la segunda testimonial.
That is in my second statement.
First witness statement that Mr. Bolo, I'm confusing everyone, Mr. Conger raised the issue of the Sunat letter at the March 8 lunch, which prompted your comment. And you testify in your second witness statement that that's actually not correct, that he raised the Sunat letter at the second meeting. Isn't that the case?
That is correct. The recollection I had during my first witness statement was that the issue of the letter was something that came up at the table during lunch. But when I started reviewing the agenda, the invitation email, and the presentation, when I saw this color presentation that I had, of which I had the original copy, I recall that it was at the end of this presentation when Mr. Conger approached me and mentioned the Senate letter.
Testimony, Mr. Tovar, is that at the first meeting, although you claim to have discussed the scope of the stability benefits, Mr. Conger did not even raise the letter that he had received from SUNAT, and that it just occurred to him after having given the PowerPoint presentation that we looked, so that he felt the need to run up to you and ask you about it. Is that your testimony?
There are some things that I can't say, whether he felt the need. That I can't say. That Mr. Conger has to say that. But did he raise it at the lunch? No. The Sunat letter was not mentioned at the Farniente lunch. It was at the end of the presentation at the ballroom at the Intercontinental. That is where he looked surprised, and he said, Mr. Tovar, how is it possible that we received this letter from Sunat? Yes, at the mine we also received it, but don't worry, the law is just now being implemented. Certainly these are informational documents. I remember that I was very calm. I knew the letter existed, even though I'd never seen it, so I explained to Harry Conger that the stability agreement covered leaching, but not primary sulfides, that would have to be addressed in the future, and his reaction was very friendly, very calm. He said, thank you very much, and left.
None of this detailed and vivid recollections of the second run-in of Mr. Conger when you drafted, you witnessed your first witness statement, Mr. Tovar, did you?
As of the response of the claimant to my first statement, for example, I'll cite, I don't recall having organized that meeting or it having taken place. And that's the claimant responded to my first statement. Well, I don't make things up, so I reviewed the emails. I reviewed the things, dates, and that's where I reviewed the Cerro Verde email, where they ask for the meeting and they ask for more officials to attend and to raise the agenda of the meeting.
President.
The tribunal has no questions, no additional questions. Thank you very much, Mr. Tovar. You are released now as a witness.
Thank you, everybody. Thank you, everybody.
Shall we continue right away with Ms. Bedoya?
Yes.
Or would the court reporters prefer a break? Okay, then we have our 15-minute break now, and then we continue afterwards. We now continue with the witness, Ms. Bedoya. Welcome to the hearing. Just to introduce ourselves, this is a tribunal, in this case, Mr. Tawil, Mr. Cremades, and myself, Inka Hanefeld. You have been called as witness by the respondent, and so we need you to read out the declaration that you have in front of you.
Buenos días.
Good morning. I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Then we come to your witness statements. Do you have your two witness statements, RWS 4 and 11, in front of you?
Sí.
Yes, I do.
Can you confirm that these are your witness statements and that they correspond to your recollection, or do you have any wishes to amend or correct these witness statements?
They are correct.
Thank you. Then we turn to the direct by the respondent.
Thank you, Madam President. And with your permission, I will turn to Spanish.
Good morning, Ms. Bedoya. Good morning. You were just asked about your witness statements. They're based on your knowledge. Are they based on your knowledge and personal experience? Yes, that's right. What is your academic background? I am an attorney, graduated from the University of Lima. I graduated in 1999. And what is your current position? At this time, I am a supervisor at Division 4, which is the Claims Management Division, the claims of the Claims Division of SUNAT. When did you begin working at SUNAT? In June of 2000. What positions have you held in SUNAT? I have been adjudicating auditor until 2014 at the Arequipa Regional Intendancy in the Claims Division. Then I was temporarily assigned to be supervisor in the Intendancy of Major National Taxpayers, also in the Claims Division. And that was up until 2015. And then from 2015 to 2017, I was also had the temporary assignment to serve as head of the Claims Division of the Regional Intendancy of Arequipa. After that, I was adjudicating auditor once again in the Intendancy of Major National Taxpayers. And in August of last year, I was once again temporarily assigned to serve as supervisor at the Intendancy of Major National Taxpayers. At paragraph 11 of your second statement, you refer to the drawing up of, I quote, the report on the application of the agreement guarantees and measures for the promotion of investments in mining royalty with respect to the expansion of Cerro Verde's current operations primary sulfides project, close quote, which you call the 2006 internal report. Why did you draw up this report, and what were your conclusions? In mid-2006, the intendant at the time, Mr. Heraldo Cruz, he asked that an investigation be undertaken with respect to the concentrator, whether the concentrator was covered by the tax stability agreement within this guarantee of stability that was offered pursuant to the signing of that agreement in 1998. At the time, the plant was not yet up and running. It was going to start operations at the end of that year, and so what was sought was to find out whether this plant was or was not encompassed by the stabilization agreement. Based on a report that SUNAT has from 2002, that report analyzed what was covered by the stability guarantees, and reviewing the investment project, we concluded that it was not covered by the stabilization guarantee. Why? Because it was a new investment, totally different, of a different amount from which did not exist at the time the agreement was signed in 1998. Moreover, in the 1998 agreement regarding the leaching project, the contract only spelled out the investment related to the leaching project and the amount, or what the output would be, leaching the material. It was copper cathodes, and the purpose of the agreement was to increase the production capacity from one given amount to another per year. So comparing the contract with the with the investment in the concentrator, we realized that it was a totally new investment and that it was different. It produces a different type of ore, which is the copper concentrate, which compared to the cathode has 26% purity compared to 99.9% purity. And so the conclusion was reached that, in effect, this plant was not covered by the agreement because the agreement covered only the leaching investment project. At page 5 of the 2006 internal report, and you just mentioned it, and you also mentioned it in your witness statement, you cite in report 263 of 2002 of SUNAT. What is the relevance of this 2002 report? The 2002 SUNAT report has been issued by the National Legal Intendancy, which is the entity within SUNAT that is in charge of elucidating any controversy there may be with respect to the application and general scope of the rules. So the National Legal Intendancy issued this report, which is binding and which is published, because the reports of the National Legal Intendancy are to be published on the website of SUNAT. And here there was an analysis of the scope of stability. It was actually in response to a consultation that was of a different sort, having to do with contributions to the FUNAVE. But the important thing is that it was made clear just what the guarantee covered. And so SUNAT on that occasion concluded that all that was covered was the investment project, which is contained in the feasibility study that is part of the agreement, and nothing more. What use did the Arequipa Intendancy make of the 2006 internal report? After the drawing up of the 2006 report, in 2008, the inspection orders or respective mining royalties were to begin, and that was for 2006-2007 and for 2008, and then later on the other assessments that came later. What was your role in the assessments made by SUNAT to Cerro Verde with regard to royalties? I was assigned the request for reconsideration after culmination of the inspection orders. The assessment resolutions were issued. The taxpayer may, as it did, challenge them, and that is called a request for reconsideration, and this is the first administrative stage. So I was assigned to once again analyze these cases in this reconsideration stage. That's what was done. The taxpayers' arguments were reviewed that they had presented in the inspection and in the request for reconsideration, as well as all the documentation produced by the taxpayer. The matter was analyzed once again, but this time it was a bit more in-depth, because we reviewed the adhesion contracts and the nature of these contracts. It was very important to define what were the benefits that the parties obligated themselves to provide when the signing of these agreements. In this case, the company, Cerro Verde, undertook to make an investment of approximately $230 million for the leaching project to expand the capacity for production of copper cathodes per year. And then the Peruvian state undertook to not change the rules of the game for 15 years, which was the time stability would last. Why? So that the investor could plan the results that they hope to obtain over those 15 years with rules of the game that would not vary. So it's evident that what the state sought with the signing of such agreements was to protect to offer protection. What was to be protected? The investment. Which one? The one that was totally spelled out and indicated in the agreement, which was the leaching project. It could not be a carte blanche for the taxpayer to continue making any other investments subsequently and claim to have the stability guarantee also cover that investment. What was the role of the Minister of Energy and Mines in SUNAT's actions in relation to these assessments? None whatsoever, because SUNAT reached the conclusion that the concentrator was outside the scope of the agreement, as I explained, as from the 2002 report. And when the investigation was undertaken in 2006, as you can see in the reports and the different resolutions issued in respect of mining royalties, mention is made of the ministry's reports, but at the end. Why? Because it was important to take stock of the sector's opinion. And we were very much struck. The sector had the same opinion that we had, and so that was helpful for reinforcing our view, which is that the concentrator definitely could not enjoy the guarantee of tax stability. Thank you.
I have a question. It is quite basic, and perhaps this would be a question to be posed to any law student. The SUNAT also is the Superintendency of Tax Administration. Are royalties considered taxes? And SUNAT also deals with royalties. They're not considered taxes, but there is a provision that was passed specifically that gave SUNAT the powers to collect those royalties and also to conduct audits and oversights in this connection. SUNAT does it based on a specific provision. It can also impose penalties on the basis of what the law established. Thank you very much. You're welcome.
Another basic question from my end regarding the rules of the organization. Is it the regular course of action that someone who has established a report, like you did in 2006, on a specific question, will later then be assigned to decide on a request for reconsideration, or was this an exceptional circumstance?
What happened is that something regular happened. The tax administration, before auditing a taxpayer, gets to know the taxpayer, specifically if this is an important company in the industry and in the region. It was completely natural and normal for the tax administration, within its powers, to investigate this. I was involved in that investigation, and a couple of years went by, and the audit was conducted, and then the taxpayer challenged it. I was appointed again for me to look at the request for reconsiderations, but there are no impediments, there are no limitations, based on the fact that, since I was involved in the report, I then could not be involved in the request for reconsideration. No, there's no impediment for that. You can do both. And then this happened in 06-07, and then in 2010, and then in 2008, and then in 2011. So there was no limitation. There is no conflict of interest. For an official to have a conflict of interest, there has to be two different overlapping interests. In the case of SUNAT officials, that is not the case, because we only have a single interest, which is to ensure that all tax obligations are established correctly and then to conduct audits. For example, a SUNAT auditor is going to see to it that the taxpayer assess the tax accordingly, pay taxes or royalties in this case as appropriate. As an adjudicating auditor, you have to look for the material truth. You have to look at all of the arguments of the taxpayer, answer all of the questions posed by the taxpayer, and we look for the truth, right, for the taxpayer to pay his or her obligation. There is no conflict of interest. Something else you have to take into account is that in the 2006 report, well, the report is an internal report. It was an investigation conducted by the administration, and the taxpayer was not involved. There was no assessment, and since there is no assessment to the taxpayer, then the taxpayer doesn't have to defend itself from anything because nothing is being asked of the taxpayer payment-wise. So you can examine an issue, and then the next year you can analyze another issue. It is also common for auditors that conduct oversight, review a company during one fiscal year, and then again. This is a mining company. The mining sector is a new sector, is a different sector. It is not common in the region of Arequipa, so it is important to become then specialized. You have to know their terminology. You have to know many issues that are very related to the mining industry. So it is very common. It's not that this was specifically done for this company at this point in time. This is the manner in which the tax administration conduct its duties. Now, the SUNAT reports to whom? Let me ask you. Do politicians have an influence in the oversight activity that SUNAT conducts? SUNAT is an autonomous organization. It does not report to any other agency. It is connected to the Ministry of Economy and Finance, but it does not really report to any organization. In the Office of Audit, we can conduct audits of any taxpayer. As the tax code says, we are there to make sure that legal provisions are complied with. Audits are not based on any kind of political pressure, in no way whatsoever. Who appoints the highest authority at SUNAT? And that high authority at SUNAT, can it have an influence on your professional activity? The government appoints the superintendent. The central government does that. It appoints the superintendent. The superintendent doesn't have any kind of influence in connection with any kind of procedure. The chief of the claims division is the one that appoints me as an auditor, and he is the only one that looks at the draft that I prepare. If he is in agreement with this, it can change the criteria or amend it, and that has to do with whatever the chief of division thinks. And in this case, this resolution was signed by the intendant. So there are a number of stages of review. First, we have the request for reconsideration. Then you go to the intendant for him to look at things. And then if he agrees, then the intendant's resolution is issued. But there is no no kind of influence whatsoever. Thank you.
Much. Then we now turn to Claimants Council.
Thank you very much, Madam President. I will be conducting Ms. Belage's cross-examination, and with your indulgence, I will do so in Spanish. Buenos días.
Good morning, Ms. Bedoya. Hello. It's a pleasure to see you again. Thank you very much for being here.
Vamos a...
Are you ready? Yes, I am. Thank you for being here with us. You know the rules of the game very well. I'm going to ask you very specific questions. I'm going to ask you to provide specific answers. And we are going to try to pace it up because of the translation, of these rules. We're going to talk about the same issues, more or less, that we touched upon in February at the Cerro Verde hearing. I'm sure the tribunal had reasons to ask questions of you back then, and this tribunal will ask you questions as well. We're going to talk about the report that Dante Martinez placed against SUNAT in July 2006, just 1 month after your internal report was prepared. So we're going to talk about new issues. We're going to talk about issues that we looked at before, and we have the transcript in connection with those matters, right? At the February meeting, we spoke about the process that you followed to prepare your witness statements. To prepare your witness statements, you reviewed the witness statements of who else? Who other witness in Peru? None. Nobody whatsoever? Nobody whatsoever. For the first and the second one? No. None? None. That's striking because you're very categorical in your answer. Because Mr. Cruz in February and Mr. Polo and Mr. Tovar as well, all of them have indicated that they received a binder, a link, or folder with all of the witness statements. So were things different in your case? You never received a folder, a link with the statements of the other witnesses? Let me explain how No, please answer my question. Did you receive a folder or no? No. So things with you were different then. The other witnesses were given a folder with all of the witness statements, but you were not. Is that what you're saying? The link I was given to come here and to read the documents only contained my statement and the exhibits cited in that statement. First statement and the second statement, that's all. That's what happened in both cases. When I was about to come here, I was given a link and I was told, okay, these are the documents, and I saw there my statement and my exhibits. I have had no contact with these statements by other witnesses. And that link, I imagine, had the memorials and that the parties have submitted, right? The claim memorial and the other memorials. Yes, just portions of them that were translated for me to see what they said about my work. Now, the portions that they sent to you, did they contain descriptions of what the other witnesses from Peru said in this case? Again, they only had to do with the portions related to me and in Spanish. We didn't have the full document. It's very long. How do you know it's very long? Well, it said there that it was a bunch of pages. Where did it say that? Well, there. You can see the number of pages there, 300 odd pages. That's what I recall. I wouldn't be able to tell you more. Were you given the full memorial or just part of the memorial? Just part of the memorial. Again, in the portions you were provided, you saw what we said in connection with the other Peru witnesses, or just a little paragraph where mention was made by us of you. That was the only thing that was given to you. Well, we're not talking about short paragraphs. There were a number of paragraphs that talked about the royalties reports. That is what I have reviewed. I have not reviewed anything with what you had to do in connection with statements by Mr. Polo, for example. You cite 46 paragraphs. First, paragraph 20, and then paragraph 200 of a reply. None of those paragraphs that you read, none of them whatsoever, mentioned anything in connection with any other witness. That is what you're confirming today? Yes, because that is what I needed for me to make my statement. I didn't really need any other additional paragraphs. Very well. We know, because of other witnesses, that there was a meeting in July 2022 in Lima in the Navarro offices. Navarro Council was present, Sidley Austin Council was present, and some witnesses were present as well. Were you at that meeting? I went there in July, but I was the only one there. Counsel from the law firm were there, but just me, no other witnesses. So they applied a different rule for you vis-a-vis other witnesses. Look, you would have to ask them why. Well, I'm trying to understand whether you're following the same rule that was applied to other witnesses, or in your case it was different. So we know that in July 2022 there was a meeting in Lima at the Navarro offices with Sidley Council, and a number of witnesses participated in it. Some were there in person, others were there remotely via video conference. You did not attend that meeting. No, I was told to go there one day at a given time, and it was just me and the lawyers. No other witnesses were present. What materials did you read to prepare for this hearing? I read the statements, the reports that support the resolutions, and the reports that the statement makes reference to. Did you read a new document, a different document, to prepare for this hearing vis-a-vis the hearing in February? The transcript of my testimony at the hearing. Just your transcript, your portion of the transcript. Yes. Did you look at the video, the audio? Well, no, it was printed out and it was given to me. When? Here in Washington. So the first time that you read your transcript was here in Washington? Yeah. It was given to you in print form. Nothing digital. No, nothing digital. How many hours did you dedicate to the preparation of this hearing? 2 hours a day. I looked at the reports. Well, this happened 20 years ago, almost. So I don't recall some of these specific points. So these things are long. You have to read. Yes, we all know. Sorry for the interruption. You need to speak one at a time, and please, a little pause between question and answer, says the court reporter. Okay, just to summarize, how many hours to review these long documents? Well, maybe a couple of hours in the morning while I have been here in Washington. Yes, but in total, how many hours did you devote to this? Perhaps 2 hours without the weekend. I don't know, Tuesday to Friday, 5-10 hours. In Lima, you did not prepare for this hearing. I've had no time almost for that. You didn't prepare? I was able to read something, but very little. I've been very busy with work. In February, Ms. Bedoya, you told us very clearly that you had met 3 or 4 times, you said, with Mr. Cruz here in Washington to review your statements and to prepare for the hearing. Now, was that the case as well? Did you also meet with Dr. Cruz to prepare for the hearing? No, not this time. So, you arrived, and this is public information, you arrived on May 1st here in D.C. Mr. Cruz arrived May 3rd. So, you've been here for about a week here in Washington, D.C. But this time you did not meet. We didn't. What changed? Why is it that you met 3 or 4 times before the February hearing to review together your statements? What changed? Why is it that you didn't meet this time? Last time around, I was present when he was looking at the statements, but we didn't do a review together. He has not looked at my statements. I am trying to specify things because your statement is that we prepare together. That is not true. We did not prepare together. Here in Washington, we have had no other contact apart from like crossing paths and saying hello to each other. Why was it done that way? I don't know. You would have to ask counsel for that. They are the ones who provide us instructions and let us know where we have to go and at what time they have to be there. 2 follow-up questions. First, you said, and this is at the transcript, in the video, and in the transcript as well, what you said in February is very clear. You said, after I asked you, did you meet with the Sidley Council to prepare the hearing, you and Mr. Cruz? You said, yes, we had meetings to speak about the issue 3 or 4 times. And then I asked, did you coordinate your statements during those meetings? Your answer, Basically, we reviewed what we had written in the statements. We were reviewing our statements, the ones that we had presented to the tribunal. So it is clear that you had 3 or 4 meetings where counsel was present, you were present, and Mr. Cruz was present. And at those meetings, you spoke and reviewed your statements. Are you changing your testimony in February? No, I'm not. Okay. Now that it's clear that those meetings did indeed take place, and you and Mr. Cruz meeting with the lawyers, you reviewed your statements, let me ask you something else. I've asked you before. Why is it that this time you didn't meet? Did you coordinate everything sufficiently in February, or there were 3 or 4 meetings there and no meeting now? There is no coordination. Each person has to read his or her own statements. Last time around, we did it at the same room, but this time we did it separately. There is no change. You have to review what you wrote in your statements and the events that you went through and the things that you have to describe about what happened back then. There was nothing wrong last time around. There was a review, but each person reviewed his or her portion. He did not listen to my statement. It's not that I was involved at the meetings. He was looking at his own statements. I'm not surprised that you're trying to put your statements into context in February. I feel that you were trying to say something that did not happen. The meaning that those meetings have, that's something that the tribunal is going to have to assess. So I have to show the tribunal the facts so the tribunal can reach the conclusion, the relevant conclusion in connection with those events. It makes no sense and that you tell me that you were in the same room, and then in February you tell me that you reviewed your statements, and then you are telling me today that you didn't hear anything in connection with Mr. Cruz. That makes really not a lot of sense, ma'am. I didn't tell you that I didn't hear anything. I'm just telling you what happened. This time around, that's the way things have been. And, if there hadn't been no changes, perhaps I could have been present or not. You said that you had heard nothing. You agree with me that that makes no sense. Last question. You confirm your testimony that in February you met 3 or 4 times, and during those meetings you reviewed your statement and you reviewed the statement of Mr. Cruz. That's on the transcript. Your answer is there confirming this, and also Mr. Cruz's answer is in there. You maintain what you said back then? Yes, I do. Ms. Bedoya. Let us now talk about your understanding in connection with the scope of the stability guarantees in connection with the general mining law that was current in 1996. I'm going to ask you about your understanding and your position in June 2006. With all due respect, I don't want to know about your position today after looking at our reply, after 3 or 4 meetings with Mr. Cruz, after the July meeting with the Navarro law firm. I'm asking you about your understanding in the year 2006, in June. Agreed? Yes. You worked in SUNAT as an adjudicating auditor from 2006 to 2014, right? Yes. I think the tribunal asked you questions, and they made this clear. In Arequipa, you have the audit division, which is the division that oversees and provides assessment resolutions, and also you have the claims division that looks at the requests for reconsideration that are submitted by taxpayers against those assessments. And they said, okay, Mr. Taxpayer, you're right, you're not right, the assessment will be maintained or not. That was the claims division. Is that correct? Yes, correct. As you confirmed to the tribunal and to my colleagues as well, you and an auditor from the audit division, Cesar Guillen, Cesar Guillen and yourself prepared an internal report of June 2006. The conclusion there was that Cerro Verde had to pay royalties for the concentrator. We're just confirming the facts, and now we're going to delve into the report later. So you and Mr. Guillen prepared the internal report, right? Yes, but it was also a team that worked on it. I don't remember all of the people. How many people sign the report? Well, just 2 people. Okay, so it was signed by you and Mr. Guillen, right? Yes. So you said clearly in your statements and at the hearing in February that that internal report shows that in June 2006, SUNAT had taken its own position in connection with the tax situation of the concentrator. You said that today, and you maintain your testimony. Is that right? Yes. Let us go step by step, then, to try to understand exactly what your position was and what Mr. Guillen's position was in June 2006 when you concluded that the concentrator had to pay royalties. First question. Please be very precise, Ms. Bedoya, because there has been much confusion in connection with this issue. We hope that you're going to shed some light on this. Let us look at this folder at 6, and this is CE12. And we're going to go to Exhibit 2 to the Stability Agreement. It should come up on the screen. And let us look at Exhibit 2. When you find it, let me know, ma'am. I haven't found it yet. You're going to see Exhibit 1, and then you're going to see Exhibit 2. I found it. It says here, summary of the investment requirements of the leaching project of Cerro Verde. This is the investment program, and it has a number of items. Do you see those? Yes. Specifically, answer yes or no. Yes. No. I'm going to ask you a question now, and then you should answer yes or no. Okay, specifically, your position in 2006 is that the scope of the stability agreement was limited to this investment program that we see here under Exhibit 2. The only thing that the stability agreement covered was these items of the investment program. Yes or no? Yes. The investment program contains a number of summarized items, but this is what's included in the technical economic and feasibility study. I agree with you 100%, yes. And then if you look at the next tab, you're going to see the full investment program. But let me ask you the question. Here we see a number of items, and your position in 2006 when you prepared this internal report that established the position of SUNAT in connection with the concentrator, well, your position was that the contract covers only these specific investments, these items specifically. That was the position of SUNAT in 2006? Yes, that's right. It is the investment program that is contained in the agreement. This investment program is for a full investment of 237 million, as you know. So what you are telling us is that only that 237 million investment is what the contract covered? That's what you're telling us? Yes, that's right. 2 questions about this. Well, maybe 3. First, we see here other costs. That's one of the items that we see here. How can we apply stability to other costs? Stability protects this project. Now, How is it that stability is going to be seen in practice? Well, stability is a legal framework that is frozen at a certain date. So all the activities related to the investment project are the ones that are included within that legal framework during the 15 years it lasts. That is how this is put into practice. Excuse me, ma'am. Excuse me. Well, I'm not a technical person. I don't know how. But yes, madam. But you had the definitive position of SUNAT. I want to know when SUNAT took this final position. What was the understanding at the time? I'm trying to explain this to you, madam.
Son las actividades que se desarrollan.
Madam President, I'm sorry. We need to stop. The stenographer says that he can only take one person at a time. If there's overlap, there is no way for him to follow the speakers. Okay, so we're hearing the translation in the background, and then we're going to be able to perhaps do this. Let's be specific, ma'am. I asked you your position when you stated the position of SUNAT when you wrote this internal report. Your position was that the stability agreement only covered the 236 million in the investment project, or did it cover something else? You just told me, yes, only in the investment program, you said. But when you have explained your position, and I'm reading, you said, no, it covered all of the activities related to leaching, and that is contradictory. Either we're talking about the 237 million and not a dollar more, or we're talking about all of the activities related to the leaching project. Which one of the two positions was the one that you had at the time?
No le comprendo la
I do not understand your question. What I understand is that the project and this investment that is stabilized, as well as all of its stages from the exploitation of the ore and until it goes throughout all the stages, and I end up with the copper cathode, and then it is sold. All of the effects of that chain, if there is a standard that says that I need to pay a tax or pay something to the workers, it is the workers to the project. If I have to pay a specific income tax that was 30 at stabilization and then it increased to 35, all of the profits will be paid at 30. That is the way I understand it. I am an attorney and I am not familiar with issues, technical issues. But I do understand that it is that situation and that there are expenses by the company that will not qualify as investments. And it is clear that a repair cost, for example, should not be questioned because I am repairing something that went wrong. So if I do not repair it, I cannot continue. But what are those costs? I do not know. I clearly see that you are not a technician or a technical person. It is clear in your answers, but I will continue to insist until I get an answer. So I'm asking you if it is only 237 million, if it is only the investment program, and you are telling me that it is more. You are telling me all of the activities. You also use the word other investments. Your position in 2006 was we have an investment program, but if there are additional investments in connection with the leaching project that we see in the feasibility study, they would be covered. No, they wouldn't be covered. So no investment, whether it is related or not to the leaching project, no investment different from the one here in the investment project would be covered, correct? Yes, no investment, only this one. I can be more specific. When Cerro Verde negotiated with the state and they wanted to know the situation of the 237 million, that is what they did. This is a 15-year project. That's why the rules show us that there shouldn't be any other additional investment. It would not be proper. That's what the standards said back then. This is what the contract also stated. We are going to refer to those projections in a minute, but let me insist again. So you just told us that no other investment, only the ones that we see here in the contract that are for 237 million. That is the only portion that was stabilized when the report was published, correct? Yes. So I have several questions. This does not seem to be what you say in your statement or what you said in the internal report or what you said in the intendant's resolution rejecting the investment. That's not what you say. So let us look at what you say, and you're going to clarify what your position is, 237 million or something else. It is the leaching project, according to the way it is stated in the feasibility study, as long as it is related to leaching. So we are going to clarify what the situation is because there is a contradiction. Let us look at your statement. Let us look at your first statement, paragraph 31, for example. I am going to read aloud what you write there. Just a second. I need to get to the paragraph. It is paragraph 31. Certainly. Very well. The stability agreement had a limited scope. The investment in the leaching project that had been defined in the feasibility study. Paragraph 31. You can also look at it on the screen. And I can repeat my question. So 31, it refers to the clauses in the stability contract. Correct. That is the last phrase. The stability agreement had a limited scope. The investment in the leaching project that had been clearly defined in the feasibility study for that investment. On Friday, Mr. Polo, when we attempted very hard to understand what his position was, told us something similar. He said, no, it is not only the 237 million, it is the leaching project as defined in the feasibility study. But here you seem to say the same, and in the internal report you have a similar comment, and the intendant's report have a similar concept. Because here we need to be specific. We don't want vague answers. We really want to understand what is it that you understood when you projected that report. Let me reiterate. Is it the 237 million that were in the investment project and that's it? Or was it the leaching project, which was broader in concept as established in the feasibility study? Which was it? I understood which one. Well, for me, they are the same. The leaching project for Cerro Verde, it is under a technical economic feasibility study, and it ends up being the 237 million. I do not see the difference. That is the part that is stabilized, the leaching project. I do not know whether any other document has a different amount, but that is what is included in the contract that has been signed. The additional investments are something else. You're asking me whether it is different. The leaching project does not entail additional investments. So once again, step by step, it seems that you're reiterating and you're saying what I meant when I said the leaching project in the feasibility study. What I meant are the 237, correct? Yes, the investment in the project, and the leaching project is only 237 million, according to you. That's what the contract states. That's what they committed to. So we agree that anything above the 237 million, anything above that would be excluded. Correct. Okay, that is the position that you are saying you maintain, correct? Yes. So that is not, Ms. Bedoya, what SUNAT has done or what you yourself said in the reports, and we are going to see what you said. You just told me that the statement is not what I said, but we just read 31. Where do I say the contrary? Because I have said that in the last portion of 31, I am not saying what I just said a minute ago. That's the reason, and that's why I have a doubt. You're telling us that when you say that the lithium project is the one protected as stated under the stability agreement, you're referring to the 237 million and nothing else, correct? Yes. That's why I'm saying we are on the same page as to your understanding. Mr. Polo told us something different, but it doesn't matter. I want to know what you understand then. So no more, there's nothing else more than this money. That is your position, and you knew, Ms. Bedoya, that in 2002, Cerro Verde had additional investment for 15.5 million, right? Did you know? No. But you mentioned them in your resolution. No, I referred to the expansion for the plant. The expansion, well, in the claim, we only had the resolution approving the authorization for the expansion. That's it, to detail the amount of the investment. I didn't know the rest. Let me show you step by step. I am going to make it very easy for you. Step by step. Number one, in 2002, Cerro Verde made additional investments for $15.5 million. We are going to show you the document confirming that indeed this is what happened. This is at tab 10. And for the record, this is Exhibit CE 378. And we're going to look at page 3. So we're going to see an executive summary of the additional investments that Cerro Verde is reporting to the Ministry of Energy and Mines for an additional 15.5 million. It's very easy. I am just helping you follow this step by step. You're going to see $15.5 million. Done? I am going to show you two resolutions by SUNAT referring to this new investment, correct? And I would like to understand what your position is, so I am going to take you there and show you two resolutions referring to the new investment, and then I am going to ask you some questions for you to have it clear in your mind. First, we're going to look at tab 12. So when you are there, please let me know, and this would be page 62.
Participate in this.
That is correct, Madam President, but this is the Resolución de Intendencia. This is the resolution for the 2010-11 royalty case, which in fact Ms. Bedoya did not issue, but Ms. Bedoya testified in the following words: in the 22 years I've been in SUNAT, this has always been the position. I am entitled to ask Ms. Bedoya about a resolution in the 2010-2011 case showing the exact opposite. This is a very
Please go
fair
ahead.
question. Thank you, Madam President. Señora Bedoya, esta es la resolución.
Ms. Bedoya, this is the intendancy resolution of the 2010-2011 royalty case. And as I mentioned before, this resolution speaks about the new investments by Cerro Verde. We are going to look at page 62. Third paragraph, where it says, note, I will be reading it aloud for the record. Note that the Assessment Department has not observed these investments made after the accomplishment of the stability agreement, considering that here not observed means that they didn't assess it or include any observation. And here comes the important portion. Considering that since they are linked, these investments, so since they are linked, the investments are linked to the Cerro Verde leaching project, their results fall within the scope of the agreement for promotion and a guarantee of investment signed with the Peruvian state. Based on this intendancy resolution, those new investments, that is to say above 237 million, these new investments are linked to the leaching project, therefore they are protected by the contract. And for the record, this is Exhibit CE 150. This is not clear here, Ms. Bedoya, that the Senate itself, Senate Arequipa, as a matter of fact, is saying, yes, there were no new investments above 237 million as new investment, but as they are related, they are linked to the leaching project, they are covered. So I go back to ask you the question, is it 237 million or is it any investment linked to the leaching project? They are contradictory, I just showed you. Let me repeat, the 237 million or any investment related to the investment project, which of the two? The 237 million, that's it. So this resolution by Senate itself is wrong. That's what you are telling us. To begin with, this resolution is no longer for the regional intendancy of Arequipa. Second, it says Cerro Verde. Cerro Verde is the main contributor, but that is not relevant. Second, I do not have the full context because you're just showing me a paragraph. I do not know in particular what investment this is referring to. If this is what you just told me, that this is for those investments, I say the following. Here it says, the assessment department has not observed these investments made after. And here we see the crux of the matter. When one carries out a tax audit, it is quite likely that the tax auditor may not determine or identify all of the risk situations where there could be a mistake or a different interpretation of the standard by the taxpayer and by SUNAT. The fact that there was an audit does not imply that the auditor had discovered all of the operations where there was a mistake. And if he didn't or she didn't do so, that doesn't mean that if I see that later on, I cannot assess it differently. That is a detection risk, as we call it, and that is what could have happened in this case. I did not participate of this resolution, therefore I am not aware of the details or why the auditor, whom I do not know who it is, may have reached that outcome. We are going to look at the resolution. Let me save the time. I just want to confirm that I understand your answer. Your answer is that the case Cerro Verde case was so important that we drafted an internal report even before the concentrator was built, before it entered into operation, before we oversaw Cerro Verde. So you had an internal report right before all of that, because Cerro Verde, the concentrator, was very important for Arequipa, but you're telling us no. What is happening here is that when they oversaw when the auditing department oversaw this, they ignored the new investments, they didn't assess them, and that's what you're telling us, right? No, I am not saying that they ignored that or they overlooked that. I think that there wasn't even an oversight back then in this year, in 2002. But it doesn't mean that this is not something that couldn't be assessed later on. But here we're talking about an expansion of the leaching project, and here we're discussing an investment that is completely different, that is a concentrator plant. We're talking about copper cathodes, and then we leapfrog to copper concentrates, which is something completely different, from 270 million to 800 million. So clearly there is from 237 million to 800 million, so there is a great difference. Yes, good news, we agree on something. So we're talking about leaching and a concentrator plant. There are different activities. Nobody is denying this, but you are now ignoring what I'm asking you, and I am familiar with you, and I know that you do this. But once again, I am going to insist until I get an answer. The concentrator is different, 850 million. Again, I understand, but here the words are very clear. Those investments are protected by the contract because they are linked. They are linked to the leaching project. But you just said these investments or the analysis is different because here these are investments related to leaching, and the concentrator was a completely different investment. Then it is different. Let me go back and reiterate, and we're going to go back to your intendancy resolution. But before I go back to your own words, I have a question. These additional investments that were above the 237 million, those additional investments that Sunat here is saying were covered since they were related to the leaching project, do you continue to maintain that it is 237 million, nothing else? Yes, it's 237 million, and that these investments therefore are not covered. That is correct. They should not be covered. Okay, let's go to your intendancy resolution. First, let it be clear. Sunat is saying something different, and you're trying to offer some context, but let us look at the resolution. If you introduce that comment, let me introduce my own. Here, you are showing me a document, but we do not know what was analyzed in that case, because from what I see, you said that it was the 2010-2011 royalty. So this is an assumption that someone is introducing, but as a matter of fact, in this case, the oversight is not part of the analysis of the new investments for 2002. That is a disputed item. So these are details that need to be borne in mind. I agree, but let me represent to you that that paragraph refers to the new investment of $15.5 million. Yes, but the context is different. The dispute is different. No one has analyzed that fact. This is an assertion by someone, but there is no underlying analysis by oversight or anyone as to determine the scope of the other investments under the leaching project, and that should be clear. Once again, the tribunal shall read that paragraph and reach the conclusions that they deem necessary, but why don't we look at your own resolution? This is tab 13. For the record, this is exhibit CE 38. And I would like for you to go to page 48. And for all of us to be clear as to what we are seeing, the intendancy resolution in the 2006-2007 royalty case, that is to say, the resolution rejecting the resolution, the Cerro Verde resolution, and also the claim, the Cerro Verde claim, and also the only audit. This is a document that you signed. Answer, that's it. Attorney, okay, let's go to paragraph 1, 2, 3, 4, 5. Perfect, it's on the screen. As it should be seen, this expansion, and once again, let me represent to you that you're referring to $15.5 million investment. If your counsel would like to show otherwise, they would have the opportunity, but let me represent to you that you're referring to those investments. Let me read to you. As can be seen, this expansion corresponds to disbursements related to the investment program contained in the submitted feasibility study. And here I would like to underscore disbursement. We're talking about new disbursements, new investments. You use the word disbursement. And then it says, this expansion is for disbursements related to the investment program contained in the submitted feasibility study. And then it adds, and since these investments were part of this investment program containing the submitted feasibility study, the contract would cover these expansions, and this does not change the object of the contract, which is limited to the expansion of their production capacity from 72,000 to 105,000 pounds, that is to say 48,000 metric tons of copper cathodes from copper ore heap leaching. So here you're not saying it's only the 237 million. You are saying that these disbursements, and it doesn't matter which ones, it says new disbursements are covered because they're related to the investment program contained in the feasibility study, and because they do not distort the purpose of the contract, which is limited to 48,000 metric tons. So I go back and ask you, is this your position, that these are disbursements in connection with the leaching project that are covered, or is it your position 237 million, nothing else? Please be specific, Ms. Bedoya. When you ask the question, you include some statements that are not included there. I cannot be specific. I need to explain. Give me some time to explain so that everyone can understand, because what you do is you read this, but you have added several words that are not there. To begin with, that paragraph does not say that the expansion is covered with the contract, so with the stability contract. Because here this is a description. The idea is to address through this document an argument about the expansion under the leaching project. This paragraph only refers to the third expansion. There were three, the first two during the contract, and this third one that is afterwards. And here it says that this expansion corresponds to disbursements related to the investment program contained in the submitted feasibility study. This paragraph comes from a different one that also refers to the expansion, and the only thing that we had to be able to work there was a resolution, as I said a minute ago, that would modify or that authorized the expansion. There was no detail as to any amount, 105 mil, or there was no explanation as to the millions or whatever amount that was. So here it is just a statement that this expansion is related to the investment program. And here it doesn't say that it is covered. It says which does not distort the object of the contract. It is not, there is no detail of the 1.5 million. So this is not against the object of the contract, because this is what I understood too, since there was no additional documentation and the taxpayer had presented this document on the expansion. I understood that the expansion was linked to the increase in production capacity from 72,000 to 105,000 million pounds, to 105,000 pounds rather. There was no study as to whether those investments were inside or outside the contract, because that was not part of the oversight analysis. As part of the claim, we can only review what the taxpayer is questioning, what is the dispute. And if these investments, new investments, were outside the project, that was not part of the dispute. So I apologize. I asked the questions and you already offered us a long explanation, but your question is not proper. Let me ask you a different one. You are saying that this was not the subject matter of the dispute, but if you look at this first paragraph on the same page, page 48, first paragraph, there it says, Cerro Verde, and you wrote the arguments for Cerro Verde. Cerro Verde argued that no one has questioned whether those investments are covered or not by the scope of the contract, of the stability agreement. So that was the dispute. It was clear, it is here on paper. It was clear that Cerro Verde had argued, listen, Sunat, in the past, you did not question that new investments would be covered with the scope of the stability agreement. Clearly, Cerro Verde said that, and you analyzed the information, you referred to the various expansions, and then in this paragraph that we just saw, you addressed that argument. So you're answering to Cerro Verde, indicating that the new investments had been covered in the contract. And when you do so, once again, you repeat, these disbursements are related to the investment program. They do not distort the object of the contract, and that justifies that they were covered. It does not distort the object of the contract because they are related to the leaching project.
That is clearly what you're saying there, Ms. Bedoya. That's what you understand. It's not what I understand. I understand that that point was not subject to analysis. The only thing that is being said there is that it's an expansion that is related to the object or objective, because that's what I saw. Now, if it's an expansion that was not related to the subject matter of the contract and went beyond it, well, there were no more documents for verifying that. And if you would allow me to, now that you're making reference to this resolution and to the report that I wrote, if I could please read a paragraph from that report so that you can better understand the position I had. I have a paragraph that I could read if you would allow me to. Yes, let's turn to your report in just a second, of course. But now I'm going to ask you another question. Yes or no? Are you familiar with any assessment by Sunat for those new investments? Here you're analyzing them. Now, at some point in time, did Sunat come up with assessments for Cerro Verde, telling them, look, these new investments are not covered? Does that assessment exist? Yes or not? That's my question. Does it exist? Yes or no? It does not exist because it's never been a subject matter of analysis. Responding to an argument in the claim doesn't mean it's been analyzed. I mentioned that here, when one is going to make an assessment, one reviews the record of the the taxpayer. Here we're talking about what year? 2006. So it's impossible that it's been possible to review documentation of 2002, because in this claim, which is based on the inspection of 2006, there was no document, nor was there any analysis of how the taxes had been determined in 2002. That was not analyzed, and it's not the subject matter of analysis in this case. Good morning. How are you? The issue has not been put forward as though there'd be a possibility of Sunat making an assessment of for the initial investments in the leaching project. So it's important for me to know at least whether that still exists. Is this your opinion, or is it the opinion of the SUNAT that the additional investments were not covered by the stability agreement? Okay. SUNAT and the report of 2002 and issued another report in 2007, and there SUNAT is even clearer, because in that report it notes that what is protected by the agreement is the investment. Indeed, it says the amount, finally, that the company executes. Now, in this case, I don't have the specific data, but I understand that an amount below 230 million was invested. So in that report by SUNAT, what SUNAT says is that what is invested is that is protected is the investment, the amount of the investment. Ma'am, you're not answering my question. My question is if there were any additional investments in the leaching project, and I'm sorry if I'm confused about the name. Is there a tax assessment by SUNAT? At this time, there's not, because we have something called statute of limitations. Yes, but apart from the statute of limitations, could there be an additional investment today in the original project? SUNAT's position is that it's not covered, that additional investments in the leaching project are not covered by new investments in the leaching project are not covered. That's right. Had there been a new one and had there been inspection, had that been analyzed, it's likely that one would have to determine an assessment there because of the additional investments in the leaching project. Now, that is different from what has been put to us. Minister Polo told us that all additional investments in the leaching project are covered, but this is a different project. You're telling us that SUNAT has a different position than what was conveyed to us. The thing is, the position taken by SUNAT is for tax purposes. Yes. So we analyze, and that's the position. It's the investment, and there could not have been additional investments. And is that position set by SUNAT no matter what the ministry says? Yes, because the one who is going to administer taxes is the tax administration, SUNAT. Thank you very much. Thank you very much, Professor Tawil. I was going right there, Ms. Bedoya, and I want to ask you once again. We're looking for the transcript of Mr. Polo's testimony in case you want to see that. But Mr. Polo did say quite clearly that the leaching project, as set forth in the feasibility study, that if there are additional investments tied to the leaching project, they may be covered as well. And the Sidley lawyers in their memorials have said things that are similar, and we're also finding the specific quotes to show them to you, because as the arbitrator, Professor Tawil, says, we've been told different things. And it's important to know exactly what was the position. So either Mr. Polo, former Vice Minister of the Ministry of Energy and Mines, is mistaken, or you and the 2010-2011 resolution, your own resolution in 2006-2007, were saying that there are other possible investments related to leaching that could be covered. Now, there couldn't be, the government cannot consistently have two different positions. You might say, no, but the Ministry of Energy and Mines, no. The government has to have a consistent position. And Mr. Polo has told us one thing, the attorneys have told us something else, the resolutions have the intendancy yet another, and you yet another. So I'm going to give you one more opportunity. I'm going to ask you one more time, if we were to check against one another all these different statements, an investment related to, tied to the leaching project, an additional investment that is tied to, related to the leaching project established in the feasibility study, could it be covered by the stability agreement? Yes or no? No. I have asked you to allow me to read a paragraph of my report. I don't know if I can. We're going to get to your report, but first I would like to confirm. Your testimony here is that Mr. Polo was mistaken, or that what he said is not accurate, and that the other documents and statements in the record saying something different, that it's not a single dollar more. Well, your testimony is any declaration to that effect is mistaken. The only position is the $230 million. Is that your testimony? No, because I have nothing to do with, and I have not heard what Mr. Polo has said, and I don't know why he said it. That's a matter that goes to him. You've said, I'm going to ask the question, and I want to know what you think, and I'm answering what I think, and that's what I think, and that's what I think is correct, and what I know is correct. And what also backs up Sunat's position in the 2002 report and in the 2007 report. For us, additional investments are not covered. Very well, Ms. Bedoya. We're going to compare once again. The tribunal will be able to see whether or not there is consistency among the members. But it's pending for me to read the one paragraph of the report. Yes, but first, it's a bit disconcerting to hear a different position from different witnesses that we have. So I'm coming before us. So I'm just trying to understand your position. Cerro Verde has submitted an investment project for $230 million. I suppose you know that that program was carried out before the signing of the stability agreement. You know that investment program was carried out, and the ministry ratified that it was carried out in late 1997 before the signing of the agreement. So your position is that from the signing of the contract and for those 15 years, if Cerro Verde invests a single additional dollar in its mining unit, a single additional dollar, then that additional dollar is outside the scope of stability. That's what you're telling us happens in practice? Yes, but now you're talking about invest, and we have to be careful there because not everything that is spent is investment. No, I'm saying if it buys a new test.
Entre una inversión y un gasto, entonces,
Yes, but I understand the difference between an investment and an expenditure.
no me responda diciendo que
Please don't answer by telling me that there's a difference between expenditure and investment. My question is if there's a new investment, that say the company buys a new truck, your position is that that truck is outside the scope of the contract? Yes, that's right, because the agreement was only for the $237 million. So if it buys 15 trucks, Cerro Verde has to separate it all out. $237 million, one regime, and the trucks, another regime. And if there's a $2 million investment, that's outside the scope as well, a different regime. So once again, not a single additional dollar. Excuse me, and so it needs to maintain separate books. The accounting has to be maintained separately within the same leaching plant to account for the additional investments? Yes. Well, so what's the situation here? Article 25 of the Regulation of the General Law on Mining indicates that the taxpayer, when having a stability guarantee, must keep annexes or exhibits that are going to help them keep that separate accounting. Now, what's the situation? Well, if Cerro Verde invested, say, $15 million, I don't know how much she was saying, then one would have to be careful because where the copper cathodes produced with the new investment are going to be governed by the stabilized, or with the original investment will be governed by the stability agreement, otherwise the common regime. So with 15 additional trucks, fine, those will be taxed at a rate different from the capital goods initially purchased. We understood this in relation to the concentrator, but let us suppose that there's going to be an expansion of the leaching plant, and now instead of producing, say, 100,000 tons, it produces 120,000 tons. Within the same plant, we need to keep a double accounting. Yes, that's right. That will have to be done. Why? Because the effect of the output from there, well, it's going to be governed by a different common regime. And so it is different, and some companies have done this. They may expand an already stabilized investment, and the new investment has to have separate accounting so as to pay the appropriate amount with respect to the other. Even though it's part of the same original project? Yes, even if it's the same original project. That's how it should work. Why? Because when one sat down with the state to negotiate At that time, it only proposed 230, and the difference isn't whether it's $1 or 800. The difference is that only this is what is stabilized, and the rest is to be governed by the common regime. It is possible to separate out the books and to have each part pay the corresponding tax, and there's not going to be a difficulty expanding an already existing project, nor if everything is being conducted within the same concession, physically speaking.
Señora Bedoya, sus
Ms. Bedoya, your answers are a bit disconcerting. I'd like to show you the counter memorial that was presented by the Republic of Peru. In this case, you see it in front of you. It's in English, but you can hear it interpreted. These are the words of the Peru's lawyers, so you can know exactly what you're looking at. And it says,
claimant argues that Peru treated certain investments made between 1999 and 2002 that were not included in the 1996 feasibility study as stabilized. Vamos ahí juntas.
so are you following me so far?
Explica un poco el contexto y después.
It explains the context a bit, and then it says,
SUNAT determined that the investments fell within the scope of the 1996 feasibility study because they were made to further the study's goal of increasing production capacity of the leaching project to 48,000 metric tons of copper cathodes per year. The fact that Peru treated these subsequent investments in the leaching project, which were intended to further the goal of the leaching project outlined in the feasibility study, and which Peru obtained pursuant to a stability agreement as stabilized. That Peru treated these subsequent investments in the leaching project as stabilized. Y para el récord,
and for the record, this is paragraph 612
del counter
of the counter memorial, the memorial that was submitted by the Peru's lawyers to the tribunal. Ms. Bedoya, you can try to contextualize or explain what you believe the lawyers of Peru are saying, but what we see up on the screen, well, we're seeing it up on the screen, and here the lawyers are clearly saying two things. First, that Peru treated these new investments as stabilized, and they're providing an explanation for that. They're saying that it treated the new investments as stabilized because
goal, porque se hicieron de
because they were made pursuant to the goals of the feasibility study of increasing production capacity of the leaching project to 48,000 metric tons per year. So once again, you are telling us today here, you're setting forth a position that is different not only from what Mr. Polo described for us, not only different from the intendancy resolution of 2010-2011, not only different from your own resolution of 2006-2007, but you have it right before you on the screen. This is what Peru's own lawyers have said. So we've devoted a lot of time to this. It is disconcerting to see changes of position, and I'm simply going to tell you one last time.
This has gone for a long time, and she has been counsel for opposing opposing counsel has been testifying and there are no questions being posed to the witness.
Of course there are. That's a very important question, whether she agrees or disagrees with statements made by counsel. And I'm very happy to ask the question again. Señora Bedoya, entonces.
Ms. Bedoya, so I was summarizing where we stand, and my specific question is, seeing up on the screen what you see on the screen what the lawyers of Peru have said, seeing this up here, do you maintain that your position was $230 million, not $1 more or less?
Ahorita no me dejó leer.
Yes, that is the position. But you say, and as against what you said in your own resolution, as though I'd contradicted myself, and that's not so. Here I have a paragraph that says the contrary, but the lawyer has not allowed me to read it. I don't know if the president could authorize me to do so.
Are you aware of the content of this settlement agreement, which is mentioned in paragraph 612?
I honestly didn't understand so well what the lawyer read. I'm so sorry. I don't know why the attorneys for Peru, if this is what if what she says is indeed what they say there, but she is talking about the position of Sunat. For me, it's quite clear. It was always consistent. All I wanted to do is read a paragraph from the resolution that I wrote up so that it can be clear, because that's not an issue that was analyzed at any time. Not in 2006, 2007 ones, nor in the 2008 one. That's why I wanted to read this paragraph. But every time that I've told her there's a paragraph that I'd also like to read, she tells me, well, we're going to get to that in just a second, but she's not allowed me thus far to read it.
Was in this paragraph 612, in this last highlighted sentence, reference is made to a settlement agreement. And my question is, are you aware of the content of this settlement agreement?
Sí, no,
I'm so sorry, but I don't know what that paragraph refers to. I'm so sorry, I hadn't read I didn't understand really what that paragraph said.
Event, it makes express reference to a settlement agreement which was concluded with Peru and which seems to concern the leaching project or whatever, the goal. And I just wanted to ask, it's quite a factual question. Are you aware of the settlement agreement and the content of the settlement agreement? No. Thank you.
no.
Yeah, my co-arbitrator suggested if you need time to read the paragraph in order to better understand the question, you are certainly welcome to do it. You have done it in the Spanish original. So if you show her the Spanish text of the submission, or
There is no Spanish
No?
text to
Okay.
the submission, Madam
Okay.
President. I can read it out loud once more, and I would actually like to draw the witness's attention to footnote 1283. I agree context is important, and that includes the footnotes included by counsel for Peru. So with your permission, I will switch to Spanish, Madam President. Señora Bedoya.
Ms. Bedoya, let's go back to the arguments that have been presented to us by the attorneys in this case, because I reiterate consistency is important. I showed you that paragraph. I read it out. I hope that the interpretation worked. Not so well, actually. Would you like me to interpret it? Sure, then I'd be able to better understand it. Okay, let's go back.
Y le estaba mostrando la nota al pie.
I was showing you footnote 1283 because the footnote is the support that was cited by the lawyers for this assertion, and it's your resolution of 2006-2007 your resolution of 2008 that has the same paragraph that we've been looking at. So I will translate that statement, which is the support cited by your lawyers for that in the footnote 1283 of your own. It's your own resolution. That is to say, they are of the view that your resolution supports this assertion, and that's why I'm going to translate it to you. In fact, Sunat determined that the investments fell within the scope of the 1996 feasibility study because they were made to further the study's goal of increasing production capacity of the leaching project to 48,000 metric tons of copper cathodes per year. And then in the footnote 1283, it cites your resolution. If we could jump to that footnote 1283. And what was the basis of that? Exhibit CE 46, which is the intendancy resolution of the royalties, of the 2008 royalties case. And they cite the paragraph that I already showed you, in which we discussed. And they underscore what the lawyers for Peru thought was especially important. What they underscored is that this expansion, and we saw above, the talk is of the new investments, corresponds to disbursements related to the investment program contained in the submitted feasibility study. And those those do not distort the main objective of the contract, which is limited to the expansion of the production capacity from or to 48,000 metric tons of copper cathodes. I hope the translation has helped. And here we see your signature on this resolution, which, according to the lawyers for Peru, support the assertion that the new investments were covered because they were done to carry out the objective of the investment project in the feasibility study. So, Ms. Bedoya, everyone here in this room, we all saw in English, we heard the translation into Spanish, that the lawyers who represent the Republic of Peru in this case were saying that these Sunat determined that those new investments were covered because they were made to carry out the objective of the leaching project that was set forth in the feasibility study. It does not say anywhere, not in the memorial by the Republic of Peru, nor in the footnote that they cite, which is your own resolution, at nowhere does it say that Sunat did not consider this point, nor does it say anywhere. No, it was the scope of the contract was limited to the 237 million. The lawyers did not say that, nor was that their reading of your intendancy resolution. So, for the last time, who understands? Whose understanding is it? Yours? Once again, I repeat, in that paragraph, all that is described is the expansion that was done in the leaching project. At that time, there was no document at hand that could be analyzed to say that it was a new investment, nor does that paragraph indicate that it is a new investment that is covered. It just says that it is related to or tied to, because at that time, since there was no documentation, it was thought that it was something that was related to the investment. And that's why, for a while, I wanted to specify the difference between a new investment, a different investment. Another thing is a disbursement. A disbursement can be to improve or repair something that might be needed. I don't have the details as to what that expansion was or what the details of it were, because those documents were not submitted in that inspection. That was an inspection on royalties, and it corresponded to 2006. That is my view on that. Those paragraphs do not say that SUNAT confirms after something was done, because nothing was done, that those additional investments are covered by the scope of the agreement. And indeed, this is mentioned in the 2007 report, where SUNAT is categorical in saying that it refers to the investment made by the company on culminating performance of the contract in those years prior to the startup of stability. So there's not been any contradiction. And I wanted to read this paragraph of the resolution that is mentioned, a different paragraph, which is paragraph 45. Paragraph 45 of what? What document are you talking about? This is the report that supports royalties 2006-2007, paragraph or page 45. They did not explain the rules of the game to you, but the lawyers for Peru will have the opportunity, once I conclude, to take you to whatever paragraph you wish, if they consider it advisable. Unfortunately, we're approaching lunch hour, and there are 2 points that I'd like to make using the time of Peru's lawyers. You'll certainly be able to review other documents, other paragraphs, but you just drew a distinction, or you're trying to explain this at least apparent contradiction by saying, well, one thing is a disbursement and another thing is a new investment. And so I'd like to show you those new investments to which Peru made a reference that we're talking about. I showed you the document thinking that if we look at things step by step, that would help refresh your memory or better understand your own resolution. But I'd like to put this up on the screen. The new investments that you call disbursements, this is what we're talking about. This, for the record, that's at CE 378. These are the new investments that we're talking about: improving the crushing facilities, the expansion of Pad 2, and the electrowinning plant, for a total value of 15.5 million. Now, for the record, it should be clear that in your resolutions and in the paragraph that we read by the lawyers for Peru, that of the investments we're talking about, of which there are documents in the record at least, which were said to be covered by the stability agreement, well, those investments come to 15.5 million in new investments. So we're not talking about just any disbursement or expenditure that you might want to distinguish in that way. That's the point. Yes, but those documents are not within the procedures. I had not seen them before. So I'll provide them to you right now so you can see them. Yes, but you can't see that something I wrote 18 years ago referred to this when I did not have this at hand. So we undertook an analysis. A paragraph was written up based on the documentation we had at that time. You cannot assert that what I was referring to was to this. No, because I never saw this. I was referring to the expansion of the documentation that was not presented to us.
That's crystal clear, madam. Unfortunately, we don't have enough time, but for the record, that expansion resolution that you're making reference to leaves it clear what the new investments were. The resolution that you saw, indicated clearly what investments we were talking about. That doesn't matter now. Let me ask you. Let's assume that you didn't have clear in your mind what investments we're talking about. We'll give you the benefit of the doubt. You already saw the position of Peru. We showed you the memorial. We showed you the footnote supporting this. Now it's clear. This investment, 15.5 million, having it clear in your mind what the investment was, and which was crushing improvement, expansion pad 2, and the SXEW leaching plant, 15.5. This was related to what Peru has done in connection and the leaching project. In your understanding, this investment in particular, once the facts are clear, this investment in particular, would it have been covered by the stability agreement, yes or no? No. No, because the regulations allowed for a new contract to be entered into for this second extension. Thank you very much. Thank you for your clarification and for being precise in connection with what your position is.
Continue with my line of questioning. I'm mindful of the time. I'm very happy to continue, and we do have some time left with Ms. Bedoya. So would you like to break for lunch, or should I continue a while further?
We can break for lunch now, if this is for you the preferred time.
We're in your hands. I'm just mindful we do have significant sort of additional questions.
Yeah, then let us break for lunch now, and then we continue 5 minutes past 2.
Thank you, Madam President.